Okay, so imagine waking up one morning and discovering the Supreme Court just made two decisions, so seismically significant, so historically unprecedented, that they fundamentally reshape America's political future, its immigration system, and possibly the next several generations. And just when you think the political landscape can't get any more explosive, Marjorie Taylor Greene drops a bombshell about a leaked phone call involving Trump and the Epstein files. Headlines are flying, pundits are panicking, and millions of Americans are left wondering what is true, what is spin, and what this means for the country. So today, I want to walk you through all of it calmly, clearly, honestly, because by the time we're done, you'll understand why historians may look back at this week as a genuine turning point in American history, and why the media is desperate to shape the narrative before you hear the real story. Let's start with the decision that instantly sent shockwaves across Washington. The Supreme Court just handed down a ruling on a Texas redistricting case that on its surface might sound like dry legal procedure. But make no mistake, this decision has the potential to completely alter the balance of power in Congress for the next decade or longer. Here is what happened from a systems perspective. Texas, like many states, draws congressional district maps, and these maps determine which areas vote together, and ultimately, who gets elected to represent them in Washington. A few years back, Texas redrew its maps in a way that analysts said would benefit Republicans significantly, potentially flipping around 5 districts from Democratic to Republican control. A lower court looked at these maps and said, wait a minute, this looks like racial gerrymandering. You are dividing people up based on race, not just politics. And that is a huge deal because, while it is perfectly legal to draw maps that favor your political party, every state does it to some degree. You absolutely cannot divide communities based on race, because that violates the Constitution. So the district court struck down Texas's maps and said they couldn't be used. Texas appealed to the Supreme Court. And here is where it gets fascinating. The Supreme Court's conservative majority overruled that lower court decision. They said the lower court didn't give enough deference to the Texas legislature's intentions. In other words, the Supreme Court said, we should presume lawmakers are acting in good faith unless there is overwhelming evidence otherwise. The court emphasized that just because a map might have racial implications in its outcome doesn't automatically mean it was drawn with racial discrimination as the intent. Now, why does this matter to you? Because this ruling doesn't just affect Texas. It sends a signal to every other Republican-controlled state that if you want to redraw your congressional maps to benefit your party politically, the Supreme Court is much more likely to let you do it, as long as you can argue your intent was partisan, not racial. And here's the thing. Partisan gerrymandering is completely legal, always has been. Both parties do it. The question has always been, where is the line between partisan advantage and racial discrimination? For years, that line has worked in a peculiar, asymmetric way, because certain demographic groups, particularly black voters, overwhelmingly vote for one party. Any attempt by Republicans to dilute Democratic voting power could be challenged as racial discrimination, even if the true intent was purely political. It created an asymmetry where Democrats could gerrymander aggressively in their states, but Republicans had to be more careful, because their gerrymandering could always be reframed as racially discriminatory. The Supreme Court ruling changes that calculus entirely. It says we're going to look more at your stated intention and give you the benefit of the doubt rather than just looking at statistical outcomes. What does this mean practically? Heading into the next round of redistricting, which happens after every census, Republican-controlled state legislators now have much more freedom to draw maps that maximize their electoral advantage. Some analysts are saying this could shift control of somewhere between 20 and 40 House seats over the next few election cycles. That is enormous. That is the difference between a narrow majority and a governing supermajority that can actually pass legislation. But if you thought that Supreme Court decision was historic, hold on, because the next one might change the very definition of American citizenship itself. On the very same day, the Supreme Court announced it would hear arguments on President Trump's executive order regarding birthright citizenship. Now, this is one of those issues that cuts right to the heart of what it means to be American, and it has been simmering under the surface of our national debate for decades. Here is the background from first principles. The 14th Amendment to the Constitution passed after the Civil War, says that anyone born in the United States is automatically a citizen. The original purpose was to ensure that formerly enslaved people and their children would be recognized as full citizens, overturning the infamous Dred Scott decision. For over 150 years, that has been interpreted to mean that virtually anyone born on American soil, regardless of their parents' legal status, becomes an American citizen at birth. It is called birthright citizenship, or sometimes jus soli, which is Latin for right of the soil. President Trump issued an executive order challenging this interpretation. His order said that children born in the United States to parents who are here illegally or who are here on temporary visas should not automatically become citizens. Predictably, this caused an uproar. Legal experts on the left said it was blatantly unconstitutional, that the 14th Amendment's language is crystal clear and can't be changed by executive order. But here is what is remarkable and what tells you something significant about the legal landscape. The Supreme Court didn't just dismiss the case. They didn't say this is obviously unconstitutional. We're not even going to waste our time. Instead, they agreed to hear full arguments. That fact alone tells you that, at least 4 justices, the number needed to grant review, think there is a real legal question here worth considering. So what is the argument? Trump's legal team points to the specific language of the 14th Amendment. It doesn't just say all persons born in the United States. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof. That phrase, subject to the jurisdiction thereof, is doing enormous work here. Trump's lawyers argue it implies a level of permanent allegiance or legal connection. They point out that children of foreign diplomats, for example, don't get automatic citizenship, even if born here, because diplomats aren't fully subject to US jurisdiction. They have diplomatic immunity. The administration's argument goes further. They cite the old Supreme Court case, Wong from 1898, and say actually if you read it carefully, it doesn't establish universal birthright citizenship. It establishes citizenship for children whose parents had established permanent domicile in the United States. The word domicile appears many times in that decision. Domicile means you've established your permanent home here, that you have ongoing ties and intent to remain. That is very different from someone who crossed the border illegally last month, or someone here on a temporary visa that expires next year. Now, does that argument hold water? Honestly, legal scholars are divided. The traditional reading has been that birthright citizenship is automatic and universal, with very narrow exceptions. But there is a counter-argument that we've actually been interpreting the 14th Amendment more broadly than its framers intended, and that the Wong Ark case was more limited than people remember. And here is the thing that should make everyone pay attention. Even analysts on networks that are typically very critical of Trump have acknowledged his legal team has a stronger argument than most people initially assumed. When you hear mainstream commentators saying, "I don't think they'll win, but they have a real case," that should tell you this isn't frivolous. The Supreme Court is going to seriously wrestle with this question. Why now? Why is this coming to a head in 2025? Part of it is the sheer scale of illegal immigration over the past several years. Estimates suggest somewhere between 15 and 30 million people entered the country illegally during the previous administration. Many of those individuals had children after arriving. Under current interpretation, all of those children are American citizens. That creates enormous practical and political implications, affecting everything from social services to voting rights to future immigration policy. And then while the entire country was focused on these Supreme Court cases, something happened that might have slipped under your radar, but is absolutely explosive in its own right. Marjorie Taylor Greene, one of Donald Trump's most loyal supporters in Congress for years, went on 60 Minutes and leaked details of a private phone conversation she had with the former president, and the subject, the Epstein files. Now, before we go further, let me set the stage. Jeffrey Epstein was a financier who died in federal custody several years ago while facing charges related to trafficking and abuse. His case involved allegations connecting him to numerous powerful people, politicians, business leaders, celebrities from both parties, and all walks of life. After his death, there have been ongoing calls for complete transparency about who Epstein was connected to and what exactly happened. Earlier this year, Congress passed something called the Epstein Files Transparency Act, which mandated that the Department of Justice release all relevant files within 30 days. Marjorie Taylor Greene was one of the members of Congress who signed onto a discharge petition to force a vote on that bill. A discharge petition is a procedural tool that allows Congress to bypass committee leadership and bring a bill directly to the floor for a vote. It is rarely successful because it requires significant bipartisan support. But in this case, the petition gained traction, and eventually the bill passed and was signed into law by President Trump. But according to Greene, that didn't happen without a fight. In her interview, she said Trump called her and was, in her words, extremely angry that she had signed the petition. She said he was furious with her for supporting the release of the files. When the interviewer asked what Trump said to justify his anger, Greene replied that he told her releasing the files would hurt people. Now you can imagine how that soundbite is playing in the media. Headlines are screaming that Trump is trying to cover something up, that he is protecting himself or his associates, that this is proof of guilt. But let's slow down and think about this more carefully, because the media has a habit of taking complex situations and boiling them down to the most inflammatory interpretation possible. First, consider the context. Trump did eventually sign the bill into law. If he were truly desperate to prevent these files from coming out, he could have vetoed it. He could have fought it much harder than he did. Instead, after initial resistance, he endorsed the transparency bill. That doesn't sound like someone engaged in a cover-up. That sounds like someone navigating a complicated political and legal situation. Second, let's think about what hurt people might actually mean. Trump is many things, but he is not stupid. He knows these files potentially implicate people across the political spectrum: Democrats, Republicans, business people, foreign dignitaries. Releasing everything without proper legal review could destroy innocent people's reputations based on nothing more than being in the same social circles as Epstein. It could compromise ongoing investigations. It could violate privacy rights of victims who don't want their stories made public. There are legitimate reasons to be cautious about a massive document dump, and Trump likely understands that better than most. Third, and this is important, Trump has survived more investigations, more legal scrutiny, more opposition research than probably any political figure in modern history. If there were genuinely damning evidence against him in the Epstein files, don't you think it would have leaked by now? Don't you think his political enemies, who've had access to vast amounts of classified and sensitive information, would have found a way to use it? The fact that we're several years past Epstein's death, and the most concrete thing anyone can point to is that Trump knew him socially decades ago, should tell you something. Now, I am not saying Trump handled this perfectly. His initial anger at Greene was probably a mistake, politically. It created an opening for his critics to insinuate things without evidence. But let's be honest about what we're seeing here. We're seeing a man who understands that releasing sensitive legal documents is more complicated than a Twitter mob demanding transparency. So how do all these stories connect? How do Supreme Court rulings about redistricting and citizenship relate to controversy over the Epstein files? On the surface, they seem completely unrelated. But look deeper, and you'll see a common thread running through everything. Institutions, under enormous pressure to redefine fundamental principles in response to changing realities. The Supreme Court is being asked to clarify what the Constitution really means in areas we thought were settled. Congressional redistricting, birthright citizenship. These aren't new questions, but they're being asked with new urgency because the facts on the ground have changed so dramatically. We have levels of illegal immigration that would have been unimaginable a generation ago. We have political polarization that makes every redistricting decision feel existential. The court can't ignore these realities. They have to provide answers, even if those answers upset half the country. Similarly, the Epstein files controversy is forcing our justice system to balance competing values. Protecting the privacy and dignity of victims, ensuring fair legal processes, but also providing transparency and accountability to the public. There is no perfect answer. Every choice involves trade-offs. But the fact that we're having these debates openly, That Congress is demanding briefings and judges are unsealing records tells you the system is working, even if it is messy and uncomfortable. And here is what I want you to understand, especially if you are feeling overwhelmed or anxious about all of this. Institutional tension is not institutional collapse. In fact, it is often a sign of health. Democracies are supposed to have these debates. Courts are supposed to reconsider precedents when circumstances change. Congress is supposed to demand transparency from the executive branch. These friction points are features, not bugs. They're how republics adapt and survive. Think about the alternative. Imagine a country where the Supreme Court never revisited old decisions, where congressional districts were frozen in place forever, where citizenship rules established 150 years ago could never be updated, where government files stayed sealed no matter what the public wanted. That wouldn't be stability. That would be stagnation. It would be a society unable to respond to new challenges, unable to correct old mistakes. So yes, these next several months are going to be turbulent. The Supreme Court will issue rulings that make millions of people angry, no matter which way they decide. The Epstein files, when they're finally released, will be picked apart by every political faction looking for ammunition against their enemies. Redistricting battles will rage in state capitals across the country. But through all that chaos, remember, this is how change happens in a constitutional republic. Not through revolution or decree, but through legal process, public debate, and institutional evolution. Now let's talk about what this means for the 2026 midterm elections, because that is where all of these abstract legal debates turn into concrete political reality. If the Supreme Court's redistricting decision stands, and there is every reason to think it will, Republican-controlled states are going to redraw congressional maps with much more confidence that courts won't second-guess them. Political analysts are estimating this could shift control of somewhere between 20 and 40 House seats over the next few election cycles. That is a staggering number when you consider that control of the House often comes down to margins of just a handful of seats. If Republicans can pick up even 20 additional seats through redistricting, it would give them a cushion large enough to govern effectively even with internal disagreements. It would make it much harder for Democrats to reclaim the majority, potentially for a decade or more. And if the birthright citizenship ruling goes the way I think it will, requiring at least one parent to have legal permanent status, the long-term political implications are even more profound. Right now, children born to illegal immigrants in the United States automatically become citizens, and when they turn 18, voters. Over time, that has reshaped the electorate in ways that favor one political party pretty significantly. If that pipeline is cut off, the demographic projections that Democrats have been counting on for future electoral success suddenly become much less certain. But beyond the partisan implications, there is a bigger question about the kind of country we want to be. Do we want immigration policy driven by whoever can get here, by any means necessary? Or do we want it driven by deliberate choices we make as a nation about who we invite to join us? Do we want citizenship to mean something substantial, a shared commitment to American values and institutions? Or do we want it to be a geographic accident of birth? These aren't easy questions, and people of good faith disagree. But here is what I believe. A country that can't control its own borders and can't define the terms of its own citizenship is a country that won't survive long term. And I think more and more Americans across the political spectrum are coming to that realization. They're tired of being told that asking basic questions about sovereignty makes them bigots. They're tired of watching millions of people skip the line while legal immigrants wait for years. They're ready for leaders who will defend American institutions and American citizenship as something valuable and worth protecting. And that is what makes this moment in late 2025 so significant. We're not just watching legal cases get decided or political dramas unfold. We're watching the fundamental premises of American governance being stress-tested. We're watching whether our institutions, courts, Congress, the presidency, have the courage and clarity to make hard decisions in defense of the national interest. So far, the signs are encouraging. The Supreme Court is willing to revisit assumptions that have gone unchallenged for decades. Congress, at least some members, are demanding transparency even when it is politically uncomfortable. A federal judge in Florida is willing to unseal records that powerful people would prefer stayed hidden. None of this is guaranteed to turn out perfectly. Courts make mistakes. Politicians act from mixed motives. Transparency can be weaponized just as easily as secrecy. But the trajectory is toward more accountability, clearer rules, and stronger enforcement of the standards we claim to believe in. And that should give all of us, regardless of political affiliation, some hope that the system still works. So what should you, as an everyday American trying to make sense of all this, take away from today's conversation? First, don't let the media tell you what to think before you've had a chance to understand the actual facts. Whether it is Supreme Court rulings or leaked phone calls, there is always more context than the headlines suggest. Second, remember that institutional tension is normal and even healthy in a democracy. When different branches of government disagree, when political leaders have public feuds, when courts overturn precedents, these are signs the system is working, not breaking. Third, understand that transparency is a double-edged sword. Yes, we should demand that government files be released and that powerful people be held accountable, but we should also recognize that not everything can or should be made public immediately. Legal processes take time. Evidence needs to be reviewed. Victims' privacy deserves protection. The fact that the Epstein files haven't been released yet doesn't automatically mean there is a cover-up. It might just mean the Department of Justice is doing its due diligence. And finally, stay engaged. Pay attention to what the Supreme Court actually says when these rulings come down. Read past the headlines. Think critically about what these decisions mean for the kind of country you want to leave to your children and grandchildren. Because at the end of the day, this isn't really about Trump or Democrats or Republicans. It is about whether America still has the institutional strength and moral clarity to govern itself according to the principles we claim to hold dear.